frequently get asked about in probate and trust litigation regarding funding assets to a trust even after the death of the settlor, the person that created the trust. So let's take an example. Say John Smith creates a revocable trust while he's alive. He indicates in that trust it's his desire that his home, his primary residence, be an asset of the trust. But for reasons we don't know, John forgets while he's alive to actually place the asset into the trust. He forgets to fund the trust with his home. So then John passes away and his trust becomes irrevocable. And the successor trustee of his trust, will call her Jane Smith. She wants to know, well, what do I do now? John says he wants his home to be in his trust. He forgot to put it into his trust. Am I stuck with a probate? Is there anything I can do to still get that home into the trust? And the answer to that question is yes. There's a famous case here in California called the estate of Heggstad. And what probate and trust litigation attorneys will do is file a petition with the court called a Heggstad petition, indicating that it was John Smith's desire, as expressed in his trust, to fund his home to his trust. He just forgot to do it while he was alive. So we think it's appropriate, Your Honor, to sign an order indicating that because of John Smith's expressed desires, it's appropriate to fund the trust, even though he's passed away, with his home. These petitions, these Heggstad petitions, are very useful to posthumously fund assets to trusts to avoid the expense and the prolonged time needed to probate an estate. So again, a very useful tool that we frequently use in our probate and trust litigation practice, a Heggstad petition, to fund assets to trusts, even though the person that created the trust, the settlor, has passed away.